Number, I think, 44.
Number 44.
All right. Number 44, Charles David Stoll. What's your name, sir?
Charles David Stowell, sir.
Which city you live in?
Cape Canaveral, Florida, sir.
How long?
My whole life, 25 years.
25 years. All right, you got a violation of probation or community service here, and you have an attorney representing Mr. Cantos. Tell me what's going on, Mr. Cantos.
Judge, Mr. Stoll was actually arrested on an on-site violation of probation and the same allegations. I believe it was September 1st. Judge Garagoslo was the judge at that time. At first appearances, he gave him a $1,000 bond. It appears that the violation of probation warrant was actually issued after that. However, he has already been arrested on an on-site in this case. As Mr. Stoll indicated, he's 25-year resident of Brevard County. He actually turned himself in back in Brevard County Jail originally on this case. He has been accepted to the Faith Farm Drug Rehabilitation Program in Boynton Beach, and we're waiting to get him into that program. He also suffers from some medical issues. He has a heart problem, endocarditis, and I know he's on medication for that. He actually spent a couple weeks in the hospital, I believe it was earlier in August. So I would ask that, given that Mr. Stoll has already posted a $1,000 bond on the on-site violation of probation in this case, I'd ask that the court...
So come he's back here now, help me out.
I think it's the same. I think what happened is the on-site, he was given an on-site violation, and then the probation officer also submitted a violation of probation warrant. The warrant was signed. I don't know that the judge realized that he actually was in custody on the on-site. I've seen them kind of slip past each other in the past.
All right, let me hear from the state. Anything from the state?
Your Honor, Kimberly Musselman for the state this afternoon, and Judge Reinman is the assigned judge over the felony court cases, and she reviewed the affidavit and warrant, and she placed a no bond status. So we would just ask that you abide by what she selected as the bond.
But the representation defense is making to me is that this matter was already brought before Judge Garagoslo, and he said a $1,000 bond. Now, if they issued a warrant subsequently, what's the bond in the warrant? The warrant usually would have a bond.
The bond is no bond. Judge Reinman put no bond.
Well, and that was signed by Judge...
Morgan Reinman.
Yeah, well, counsel, time and again they've told us we have no authority to vacate this bond. I wish I could help you, and I can see your argument, but I don't want to go what standard procedure. The felony judges said, listen, we know this person. We set it at no bond. Sir, you have no bond right now, but your attorney will petition the felony judge. This is just a temporary situation. You understand that?
Yes, sir. No possible way GPS monitor or anything?
No, sir. No, sir. Because I cannot go against what the felony judge says. Your attorney will petition the felony judge for a bond hearing, at which time the state and the defense will be present, and the judge will act accordingly because they know you and they know your case. But right now, I cannot interfere with the judge's bond. Understand that?
Yes, sir.
That will conclude this matter. He's got a no bond. The affidavit on the warrant will act as probable cause. He's got private counsel, and you can seek a bond review with the felony judge.
Yes, sir. Thank you, Judge.
Have a good day, sir. Your matter is concluded.
Thank you.
Thank you. Good to see you. Ladies and gentlemen, just go right out and you get out. Ladies and gentlemen, I'm Judge Majeed. I want to explain to you that when you come before the court, you have many rights. I will walk an extra mile to respect and protect all your rights. I'm now going to explain some of those rights to you. You have a right to be heard. Anything you wish to say to me, rest assured I will look at you, I will listen to you, I will treat you with respect and dignity. All your rights will be respected and protected. In fairness to you, you must be told that everything you say could and would be used against you at a later date because it's recorded. And so you want to be careful how you speak and do not become a witness against yourself. On the other hand, you have a right to remain silent. Should you wish to remain silent, no one can force you to speak. You have a right to be represented by an attorney. I have appointed the public defender to represent each and every one of you unless you have your own attorney. For the public defender to represent you, you have to fill out some paperwork to show that you're indigent. If you do not fill out the paperwork, he cannot represent you. You have a right to know what you're charged with. We're going to read your charges to you. Give all the paperwork pertaining to your charges to the public defender, who will then pass them on to you. You have a right to a fair and reasonable bond. I take many factors into account before I set your bond. We have no desire to keep any of you in the county jail unless you have earned that through your past record. One factor that's high in my mind when I decide to set the bond is whether or not you're going to have the potential to cause harm to others. Or on the other hand, if there's a potential that others will harm you. And those factors I take into account. So now when we call you up, you will come forward to the podium. We will address your case. Now the first case we have is the matter of Aquendo, number 6 on the docket. State your name.
Roberto Aquendo.
I really can't hear you.
Roberto Aquendo.
That's not number 6 on the docket. Robert Aquendo.
He's number 38.
Take ahead. Where is that?
Number 38 and 39.
Thank you very much. I was looking at number 6. 38 and 39. Okay, Mr. Aquendo, you have 2 cases, sir.
Yes, sir.
Says you possess material depicting sexual conduct by a child.
Yes.
You have 1, 2, 3, 4, 5, 6 counts.
Right.
And then you're charged with driving while license suspended or revoked. Now we're going to take a look here and see on the computer what do we have with Mr. Aquendo. Arrest affidavit. Mr. Aquendo, which city you live in, sir?
Melbourne.
How many years?
About 4 or 5 months.
Where did you live before that?
Sebastian.
What brought you from Sebastian to Melbourne?
Moving. The house was under foreclosure at the time.
So you're living in a house that's in foreclosure?
No, right now I'm not living there at that house. I am living with a friend. Was
In Melbourne?
in Melbourne, yes.
And in Sebastian, you were living with whom?
With my kids and my girlfriend.
And that house is in foreclosure?
It was, and now they live in Palm Bay, sir.
Okay. Let's see what it says here. The defendant was arrested for a traffic offense. As a result, information was received that the defendant had an image of a minor female child, approximately 4 years old, on Mr. Aquendo's cellular telephone, where the image was focused on the child's vagina. In a post-Miranda interview, the defendant confessed to downloading, possessing, and producing images of child pornography on the cellular telephone that he had in his possession.
Excuse me, Your Honor, if I may. Herb Kellner, Office of the Public Defender. I'm a little unsure. Are you appointing the office a blanket appointment, meaning am I representing this client now, or will you make the appointment after you're done?
I was hoping to do that when I'm done to inquire about his indigency status.
All righty, then I misinterpreted what you said in your opening. Thank you very much for the clarification.
Thank you. The defendant confessed to downloading. Let's say a search warrant was obtained. And then the preliminary examination was conducted. A total of 6 digital photographs, both male and female children, ranging from 0 to 7. Sexual in nature. Telephone was seized for further examination and evaluation. Sir, how long you live in the state of Florida?
All my life.
Where did you went to high school?
Yes, sir. In Miami.
Where?
Miami.
Pardon me?
Miami.
Well, you Miami, Sebastian,
I've moved around a lot.
Palm Bay, Melbourne. You seem to be moving around.
Yes, sir. I have been moving around.
Why is that?
Different situations.
I see. Who you live with in Melbourne?
Right now, it was just a friend who was helping me out with a place to stay.
Is a male or a female friend?
She's an older lady, yes.
Older lady?
Yes, ma'am, sir.
You have any brothers or sisters?
I have a brother and 2 sisters, yes.
Where do they live?
They live in Miami.
They know that you're in the county jail here?
Nobody knows.
Well, I need to contact someone for you and let them know.
Mm-hmm.
Anyway, you have the money to pay for your own attorney?
I have nothing, no.
So you cannot afford an attorney. Did you fill out the paperwork?
Yes, sir.
I don't seem to have
Madam
it.
Clerk, is he deemed indigent?
I don't seem to have it, Your Honor.
Counsel for the defense, do you have any paperwork with this gentleman filled out?
Anything
The
that I
clerks
have-
don't have any affidavit of indigency from him.
Hold on. It might be misfiled. Just
Tell us your first name, sir.
My first name is Roberto
Last name?
Oquendo.
I found it. He's indigent.
Okay. I'm going to appoint the public defender to represent him now. As clerks having determined that he's indigent, they found the paperwork. I find there's probable cause to hold him in each and every count. We have 1, 2, 3, 4, 5, 6 counts. I'm looking at his record now. Can you find his record here for me? Where is it? Robert Oquendo, number 6. Okay, I got it here. State, I'm looking at his record. Do we have a proper record? This man is on the move. He's in Miami, he's in Sebastian, he's in Palm Bay, he's in Melbourne. Do we have a proper record for him?
Yes, it appears that that's his record, Your Honor.
His bond on each count will be $75,000, madam, each count. $75,000 times 1, 2, 3, 4, 5, 6. Driving while license suspended or revoked, his bond will be $2,500. Sir,
Yes, sir.
you are not to own any cell phones, any electronic device on which you can download anything. You understand that?
Yes, sir.
You're to stay away from all children under the age of 18 years, male and female. You understand that?
Yes, sir.
Any other condition, terms and conditions the state might wish to request at this time?
Yes, Your Honor. In addition to, you said no electronics, but we just want to specify no computer, no tablet, no smartphone, no camera.
Well, I did not want to mention it because there's always a hazard if you start listing things, because if something is not on the list, he's going to say, well, that's not on the list. I'm saying
agree.
any...
I agree. I
Pardon?
think it's electronics. I just want to stress the no camera. Also, if the court...
I said anything that on which you can download something or take a picture.
And also, Your Honor, we'd ask for no internet access, that he not access the internet, that the court consider a GPS monitor at his expense, and that he remain in Brevard County at this time, too. I don't know if he's in possession of a passport, but we would even ask for relinquishment of his passport, if the court would order.
Okay, Madam Clerk.
Yes.
One, I'm going to order GPS monitor. He's indigent. I know the indigent monitor is only for domestic violence cases,
Correct.
but I'm going to order that he be placed on a monitor. How he's going to pay for this monitor, I don't know. Secondly, I'm going to order that he surrenders any passport, travel documents, etc. he might have so that he does not leave the jurisdiction. Anything else, State?
If you would order that he'd remain in Brevard County also.
Right. You cannot leave Brevard County. You understand that, sir?
Yes, sir.
Until further order of court. So there are three specific things, Madam Clerk. One is not to own, possess, carry, or have access to any type of electronic equipment that take pictures or on which can receive downloads of any type. I'm not going to list those equipment because if something is left off the list, they'll say, oh, well, that's not on the list. Secondly, is to surrender all travel documents, including passports. He is to have the electronic monitor before he is released. And finally, is to remain in Brevard County all until further order of court. Complete stay away from any children, male or female, under the age of 18 years of age. Bond per count is $75,000. As with DWLS, $2,500. Not to own, possess, or carry any suspended driver's license. Not to drive a vehicle without a valid license. Do you have that all, Madam Clerk?
Yes, sir.
Any questions you have, sir? Anything you're not clear about? Any questions you have for me?
No, sir.
Public defender appointed after review of his documents. At this time, sir, I must advise you of your rights. Now that I've appointed counsel to represent you, you will be well advised to let your attorney do the talking. You understand that?
Yes, sir.
Probable cause in each and every count, madam. Counsel appointed, bond set on each and every count. Your matter is concluded, sir. Siéntese, por favor.
Excuse me, what's your name? Miller? What's on your case?
The next matter I have is Regional Counsel, number 3 on the add-on. Number 3 will be number 4 on the docket. Regional Counsel, who would that be, madam? Number 4 on the docket.
Judge Michelle Campbell on behalf of the Regional Conflicts Council for Adorian Ferguson.
He's number 3 on the add-on docket.
I see that, number 3 on the add-on docket. What's the name of the defendant, counsel?
His name is Adorian Ferguson.
I'm missing something here, fellas.
Number 3, add-ons.
Add-ons, okay. I'm looking at them. Take out of order. Madam Clerk, I'm looking at the take out of order instead of the add-ons. Okay, madam, I have Dorian Antonio Ferguson. You got regional conflict. Where is he right now?
Judge, I'm waiving his appearance. He's upstairs.
He's upstairs?
Yes, sir. He's a juvenile.
What would you like to tell the court?
Judge, we're just here to ask the court to set a reasonable bond on count 1, as it's currently no bond. Count 2 is at $15,000.
The gentleman is charged with attempted first-degree premeditated homicide, discharge of a firearm from a vehicle. How old is he, counsel?
He's 16, Your Honor.
Let me hear from the state.
Your Honor, the state would ask that the bond stay at none. He is alleged to have shot a 14-year-old, and he's a danger to our community and poses a threat to the victim, of course, so we'd ask that there be no bond.
Judge, of course, we believe that he would be entitled to a bond until the state has a hearing to determine that he is a danger to the community, or there is nothing sufficient that would bring him back to court. And I believe he's been a resident here. He has a place to live here. He has family here. And he obviously has limited financial ability to post bond.
All right, State, all I have here, we have an affidavit, is an order of transfer, direct file, attempted first-degree premeditated homicide while inflicting great bodily harm. Judge Maloney, order of transfer. Where are we transferring him from? Juvenile?
Yes, Judge.
Yes, to adult court from juvenile court.
Anything else, counsel?
No, Judge.
Well, it says here, inflicted great bodily harm. I'm not so sure I need a hearing to decide whether or not he's going to harm someone after I have a sworn affidavit that he discharged a firearm and inflicted great bodily harm. In any event, one of the factors I have to take into account, counsel, as you heard me say earlier, one, the person's potential to do harm to life or limb, but not only that, the potential for others to harm his life and limb. It looks to me like both of those circumstances are present here. Under the circumstances, in an abundance of caution, to protect the life and limb of innocent parties, including the defendant himself or the accused himself, attempted first-degree homicide will remain at no bond pending review by the felony court. And discharge of a firearm, his bond will be $100,000 cash or surety, all pending review by the felony court. You understand, counsel, that this bond is just a temporary matter. I'm sure you'll take it up to the felony judge, who will have the benefit of more facts than I have, and a decision will be made on my decision. So that will be my ruling. I find there's probable cause to hold him in each and every count. He has conflict attorney, count 1. No bond, count 2. Madam Clerk, what did we set on count 2?
$100,000.
That's correct. Anything else, counsel?
No, Judge. Thank you.
I will conclude this matter. We now have Ms. Bren Brito here. Counsel, tell me which case you have.
Judge, I'm here on behalf of Alden White.
Alden White, and that will be number, let's see.
48.
Thank you very much. Alden White. Yes, sir. Which city you live in?
Tylersville, Florida.
How many years?
24.
Pardon me?
24.
You lived there for 24 years?
Yes, sir.
And where did you live for the other 24?
Tylersville. The other 24 I ain't lived long. I ain't lived that yet.
I was just letting you know, the chair to instruct Mr. White to barely answer your questions other than yes, sir, and no, sir.
Your lawyer said you were only advised to speak to me and no one else. Now, Ms. Brito, why don't you announce that you're here and why you're here? Help the court, please.
Yes, this is Brenda Brito. I'm here on behalf of Mr. White. I'm here for his first appearance, Judge. We stipulate to probable cause and ask for a bond on count 2. He's being held no bond on that per the administrative order.
What says the state on count 2?
Your Honor, the state would ask for $30,000. It's a trafficking count, pretty serious offense, and he does have 5 felony drug convictions. He has 2 prior fleeing and eludings. He has, because count 1 is a fleeing and eluding, he has a conviction in 2012 and 2015, so we'd even ask the court to consider increasing that bond because of the priors. And he does appear to have 1 failure to appear.
So you're asking for how much on count 2?
We'd ask $30,000.
Let me hear from the defense.
Well, Judge, he's got, I mean, the fleeing and eluding in this case is very slim. He's got $5,000 on that count, $2,000 on the cocaine, and $2,000 on the controlled substance, and $500 on each of the paraphernalia. So I'm asking for $10,000 on the hydrocodone or hydromorphone trafficking charge. It was really a possession charge. So
I find there probable cause to hold him in each and every count. He will retain counsel. And as to count 1, the bond remain unchanged. Count 2, the bond will be $10,000. Count 3 remain unchanged. Count 4, 5, and 6 all remain unchanged.
thank you, sir.
Anything else we need to address, counsel?
No, sir.
State?
Your Honor, there's a co-defendant. We'd ask no contact with the co-defendant. Her name is Takia Frazier. It's alleged that he was passing the drugs to her in the booking, and the officers witnessed that.
Okay, give the clerk the name. You have to stay away from this person. You understand that, sir?
That's my girlfriend. We live together, sir.
You got to stay away from her now.
Okay, okay.
I have the name.
You
It's in the
understand that?
923.
Yes, sir.
Because now she's a state witness. You might be charged with tampering with state's witness. You don't want to do that, do you?
No, sir.
Good. So I'm advising you. Secondly, I'll advise you that you have private counsel. Whenever you come forward to the court, you make sure that you leave the talking to your attorney. You understand that?
Yes, sir.
Anything you don't understand? Any questions you have for me?
No, sir.
Anything else, counsel?
No, sir.
This will conclude this matter. Have a seat, sir.
Okay.
She's on the takeout order list? No. What do they do? Where is he? Huh? Oh, I thought the first guy was.
Miller.
Miller's here. And? This is what they want to do. You got your paperwork, right? Yeah, I'll give you the paperwork. This is on the warrant.
Sebastian Holly is number 1.
Your Honor, we need to take Miller, number 35. The media is here on her.
Number 35.
Yes, sir.
All right, let's see what we have. Number 35, Ann Frances Miller.
Yes, Your Honor.
We got an arrest. Miss Miller, good afternoon to you.
Good afternoon to you.
I didn't hear you.
Good afternoon to you.
Which city do you live in?
Cape Canaveral.
How long?
About 4 months. Merritt
Where
Island.
did you live before?
Merritt
Where did you
Island.
live before? Merritt Island?
Yes, sir.
How long have you lived in Brevard County?
4 years. 4 years.
And what caused you to move from Merritt Island? That's a lovely place. Why would you want to move from there?
We found a much nicer place in Cape Canaveral for about the same price, and it's closer to the water.
I see.
And I work in Cocoa Beach, so it's much more convenient.
What type of work you do?
Currently I'm cleaning hotels.
And you're a single person?
No, I'm married.
You have any young children?
I have 2 children,
How old?
7 and 9.
And they live with you?
They do.
All right. You have an arrest warrant. You're charged with exploiting an elderly person, an organized fraud. Let's see what the allegations are. Do you have the money to pay for your own attorney?
No, sir, I do not.
Let's take a look at what it says here. Ann Frances Miller. All right, let's see here. Ann Frances, we got a picture of you here. On Monday, approximately, deputy was dispatched to Sail Lane, Merritt Island. He hired Ann Miller to be his caregiver. Miller assisted Mr. Nasser and a quadriplegic. Paid Miller $35 per hour. Was paid by check every 15 days. Got a check for $263. He did not write the check. While reviewing his bank records, he discovered several checks that he did not write. He also discovered a check that was written out to a male named Nathan Sesko. He obtained her Florida driver's license number and date of birth. conducted a search on Facebook for Miller. Was able to locate both of them. Well, you understand the charge, madam?
I do, Your Honor.
It's a shame these days people are very hard to find work. Someone gave you a job, trusted you. I'm sure there's another side to the story, but right now it ain't looking very good for you. Several checks taken from the person who wanted you to take care of them, and they paid you pretty good, $36 an hour. That what it was?
Yes, Your Honor, but I worked for him 2 hours a day.
How many hours?
2.
2 hours a day?
Yes, sir.
Oh, that's pretty good pay, no matter how many hours a day you work. $35 an hour? All right, requires caregiver to be cleaning his residence while helping prepare himself to go. During the interview, I took picture in his electric wheelchair. He was not able to open his hands and grasp items with either hand. Pretty heartless, madam. Okay, I find there probable cause to hold. Do you have the money to pay for your own attorney?
No, Your Honor.
Madam, I'm readdressing the matter of her bond. Count 1, her bond will be $50,000 cash or surety.
Excuse me, Judge,
And,
if I may.
pardon me?
Are you going to appoint us yet, or?
Public defender appointed. Let's hear the public defender.
Thank you. Your Honor, this court has taken a position in the past that they have not interfered with the bonds that was set in the warrant. And there's a warrant issued here. So I'd just like, for clarification purposes, are you going to exercise your authority now consistently for today in reviewing the bonds that are stated in the warrants?
Your Honor, if I may, there is a warrant. However, our office actually has filed the charges. So there is, the warrant actually involved 8 counts. Our office filed 2 counts. So there's count 1, exploitation, and count 2, organized fraud. And, once that's filed, I believe that the court obviously...
Just for the defense benefit, yes, I'm now reviewing the matter based on the facts in front of me, and for the benefit of defense, most times I reduce the bond. Now that the filing is different from what the warrant says, most times because the charges filed are reduced the bond. There are rare occasions, very rare as they are, I will increase the bond. This is one of them. I find if the allegations were true, this is a very heartless, ruthless, willful, and deliberate deed. I am not passing judgment on the facts right now, but I'm going strictly by the affidavit, where someone trusted someone and they violated that trust. Your count 1, the bond is $50,000. Count 2, the bond is $75,000. You complete stay away from this gentleman, his home. You understand that?
Yes, Your Honor.
Probable cause in each and every count, public defender appointed. Once again, for the benefit of the state and defense, most times when I review this matter, based on a change in the charge, I'm able to reduce the bond. That happens in 99% of the time.
Your Honor,
but not in this one. Pardon me, let's hear from the state. Any other terms and conditions that may be applicable in this matter?
Yes, one more we would ask. We did hear the defendant say that she's currently working as a cleaner at hotels, but we would ask that she be ordered by this court not to work as a caregiver during the pendency of this case. I don't want her to, if she loses that job, I certainly wouldn't want her to work as a caregiver somewhere else while this case is pending.
Let me hear from the defense. Defense has a right to input. Let's hear from the defense.
Oh, thank you for letting us give you some input, Judge. Telling a person not to earn a living is pretty difficult. If it were a doctor, would you tell the doctor he can't practice medicine, or the lawyer he can't practice until there's a hearing or a determination? Although I do understand the state's request, that's a very difficult request to grant, being that you're telling a person they can't earn a living at the only thing they can do.
Thank you. The defense is doing a very fine job in assisting their client and aiding the court. Ma'am, you're not to accept any employment as a caregiver for anyone over the age of 50 years old. Do you understand that?
Yes, Your Honor.
This will conclude this matter.
Thank you.
I also want the record to reflect that the court is not saying that 50 years is old. I'm not making a comment on young or old, just an arbitrary age cutoff time. So let's move on to the next case, folks. The next one will be Holly, number 2 on the docket. What's your name, sir?
Sebastian Holly.
Kawan Sebastian Holly, is that what I have here? We got a fugitive warrant from Georgia. Are you going back freely and voluntarily?
Your Honor, this is an on-site, so it's an interstate compact case. He's going to get the 15-day control date for Georgia to obtain a warrant.
Okay, that will be granted. Have a seat, sir. Public defender appointed. Do we appoint a public defender, madam?
No, sir.
Okay. Deputy, we need to pull that mic down a little bit. I'm having trouble hearing the folks today. Have a seat, folks. We really need to change that mic setup. Foreign people are in wheelchair and all. Next case that I have then is Darius Smith, number 3 in the docket.
Everyone say their name when they come to
Oh,
the...
Benjamin Speckmeyer, sir.
What happened with Darius Smith from
He was released per teletype.
Benjamin Speckmeyer?
Yes, sir.
Number 4 on the docket. We got a fugitive warrant, no warrant recorded. Please close out case. I want you to close out this case, madam. Where do you live, sir?
Merritt Island, sir.
And there you were wanted in what state, madam, this fugitive warrant?
This was an on-site from Virginia, and they did not obtain a warrant, so they're asking that the case be dismissed, and he'll be released on this.
When you going back to Virginia, sir?
When do I go back to Virginia?
Yeah.
I don't go back to Virginia. My probation is through here in Florida. I had interstate compact down here. I own a house in Merritt Island, sir.
I see.
Yes, sir.
Okay, have a seat, sir. Your matter's concluded.
So I'll be released tonight, sir?
That I can't say. That's a matter for the jail.
All right, thank you.
Scott Dalton, Your Honor.
Next matter I have is Scott Dalton, number 17.
Yes, sir.
Battery, domestic violence, resisting. You got to stay away from Laurie R. Tripp. You understand that?
Yes, sir.
Don't call, don't visit, don't have anything to do with her. Scott Paul Dalton. Man, you got a, how old are you?
51, sir.
You got a life of crime, sir.
Had a hard one.
Outstanding warrant, failure to appear in a DUI in Artesia, New Mexico. They want you to go back to New Mexico. You understand that?
Yes.
Laurie, stay away from Laurie. Don't call, don't visit, don't have anything to do with her. Don't go to her home, don't go to her work. You understand that?
Yes, sir. I was just keeping her from staying at the Circle K where we was trespassed from.
I understand that. You're a good guy. You're a very good guy. Count 1 will be $5,000 cash or surety. Count 2, $1,000 cash or surety.
Can we just plead it out, sir?
Yes, the state's offering you a time of 5 years in prison. You want to enter a plea today?
No.
You sure?
No. For misdemeanor.
Yeah. You ever heard the old saying, you asked for it, you got it?
I heard you, sir. I was just wanting to get it done because we got appointments for our eyes and that to be done.
I see. Exposure of sexual organs, 25.
That was here in the jail, sir, when I was changing.
I see. Have a seat. Your matter is concluded. Probable cause in each and every count. Public defender appointed.
So was that 2,500 on count 3?
Correct.
Thank you.
Your Honor, number 5, Hegerstrom, surety bonded.
Number 5, surety bonded.
Yes, Your Honor.
Number 7, Dylan Ramroop. Is that you, sir?
That is me. I'm Dylan Ramroop.
Which city you live in?
Cocoa, Florida.
What type of work you do?
I'm unemployed at the moment.
I didn't hear you.
Unemployed.
Charged with domestic violence on Jagwanti Ramroop. Complete stay away, don't call, don't visit. You understand that?
Yes.
Do you understand that, sir?
Yes, sir.
Do not go where she works. Do not go where she lives. How long you live in Cocoa, Florida?
13 years.
What type of work you do? You unemployed, you said?
Yes, sir.
When was the last time you worked?
Just odd jobs for like fixing cars and stuff. Other than that,
What type of work does she do?
She's a CNA.
Are you having trouble hearing them or just me? Looking at your record, sir. False imprisonment and batteries 2013. Battery DV 2013. Battery 2010 dropped. Your mother. The person that you committed this offense on is your mother.
I'm falsely accused for that one.
Pardon me?
I was falsely accused for that one.
All right, let's hear what they say, sir. Take a look at the record. Says you knowingly and willfully battered your mother against her will. September, upon arrival, I made contact who identified as Mrs. Ramroop, Jagwanti Ramroop, advised that she was involved in a verbal with her son. Her son got upset at her a few nights prior because she would not let him use her vehicle because she was attempting to search his room looking for drugs. That after he continued to argue with her, he grabbed her hair, which was in a long single braid, and pulled it, smacked the side of her ear, and pushed her out of his room. Her son has not been acting normal, that her constantly referred to her as a devil and a demon. He's known to abuse alcohol, which she advised that she believes he had been He does not suffer from any medical condition and does not take any medications. Said he barricaded himself in the room with a family pit bull.
That's my personal dog. It's not the family.
You will be charged with kidnapping a pit bull next time, sir.
And I was in my room. She kicked in the door, and then my dog was about to get out. So.
How old are you?
24.
Pardon me?
24.
You need to get a job and get your own place.
Yeah. But I did not grab her or nothing. She'd, for lack of better words, trying to show me who's boss. She was been for a couple of days trying to call the cops. I actually had messaged some people beforehand this whole happened, saying what she was trying to do, and that as soon as I got out of my room, they stole my phone and my Bible, and then she turned off the antivirus on my phone so I couldn't track it, and then so anytime I'd left the house or anything, she was like taking and moving and messing with my stuff. So then when I did actually go in the room, you could see there are hatchet marks on the side of the door where she hit it with the hatchet, then kicked in the door. So that's when she said that I had an altercation with her, and then the cops had came. So I was in my room for the whole entire time with my dog because I know.
I see.
Yeah.
All right, I've had a chance to listen to you, and you listen to me now.
Yes, sir.
You got some serious problems. if the witness against you is your mother, you got some serious problems. When your own mother, you're accusing her of lying, that she said you pulled her hair and slapped her because she wants to keep you away from the drugs and the dope dealers. But you want to bully her and get her a car and probably get her money also in the process.
That is incorrect, sir.
So I'm gonna give you some help, because there's no point you going back to live with a mother who's gonna lie on you again. So you staying here in my care, okay? I'll take care of you. And you can rest assured I'm not gonna lie on you. Now where is the pit bull now?
At my house. Well, at the house.
Who's taking care of the pit bull?
I went for a walk, and when I came back, a cop...
I said, who's taking care of the pit bull
right
now?
I'm not aware of who's taking care of the pit bull. Possibly my sister.
I see. Yeah, Bond, you gotta stay away from your mom. Do not go back where she lives or where she works. You understand that?
Yes, sir.
Do not call her, do not visit her, do not have anything to do with her. Because as you yourself said, all she does is lie on you. Why would you want to contact such a person, right? Complete stay away. Don't go anywhere near her. Your bond is $25,000 cash or surety. No return, no contact.
Thanks, Your Honor.
Have a seat. Public defender appointed.
Curtis R. Clausen, Crown Point, Indiana, and I've been living there about almost 4 months.
Add-on number 1. Says sex offender failed to register. You got an arrest warrant, madam? The affidavit will act as probable cause. All bond and the warrant remain unchanged.
And I don't have a PDF affidavit for him, so I'm not sure if he's hiring or not.
I have $2,000 on each count here. Sex offender failed to register. Sex offender failed to report. Sex offender notified with intent to live in another state. And the warrant, what's the bond on the warrant state? Do you know?
Yeah, the bonds runner are $2,000 each one, which counts.
Remain unchanged. Public defender appointed. Have a seat, sir.
We can't accept the appointment. He hasn't filled out an application.
Well, I've said before, I'm going to say once again, folks, if you do not fill out the application, the public defender cannot represent you. We will put him down as representing himself. Next. Dylan Payne. I thought we took care of that. Number 5 on the add-on. Possession of less than 20 grams, possession of drug paraphernalia, loitering and prowling. I find it probable cause to hold him. Less than 20 grams, madam, $100. Paraphernalia, $100. Loitering and prowling, $100. Probable cause in each and every count, public defender appointed. Next, Lance Stein, add-on number 7.
He's surety bonded.
Surety bonded, Your Honor.
All right, the next one then will be Bogus, Bridget Bogus, number 7 on the docket.
Yes, sir. Bridget Bogus, Melbourne, Florida, for 31 years.
I wish if everyone will speak up like you, madam. I can hear you very clearly. I have trouble with the others. Possession of cocaine, you got a violation of probation. The judge set your bond at $2,000. Affidavit will act as probable cause. Your bond will remain unchanged, madam.
Thank you.
Serena Pagan, number 40.
Serena Pagan, Orlando, Florida, and I've lived there 15 years.
Which city do you live in, madam?
Orlando, Florida.
Oh, you're far away from home. What brought you to Brevard County?
I work part-time here and part-time in Florida.
And what's going on with the arm?
I broke it. I guess they broke it during booking and processing, so I just had surgery.
I see. You're charged now, madam, with failure to appear for early resolution. Is that correct, folks?
Yes.
Early
Yes.
resolution means everybody's trying to help you. You understand that?
Yes.
And you failed to appear. Why is that?
At the time, I wasn't aware of why I was arrested. I really don't remember a lot about what happened or what went on. But I didn't receive any paperwork, and the paperwork that I did receive didn't show me anything, so I asked my bondsman what my court date was. He said the 18th. I had been unaware that I missed it, and it wasn't on the 18th of the following
I
month.
see.
So it's just
Anyway, the judge said judge set her bond at early $11,000. I'm going to reduce that bond $3,500. Public defender appointed. Have a seat.
Your Honor, on the last
Next
case,
matter will be Nicholas Cross.
Your Honor, if I may, on bogus, you didn't appoint the public defender. Is that intentional?
Say that again.
On the case of Bridget Bogus, you did not appoint the office of the public defender.
I will appoint a public defender. Thank you. One of them did not fill out the paperwork. That person will represent himself.
That was Clausen.
Okay. On bogus, I appoint the public defender. Thank you for bringing it to my attention. I do so also for Pagan. Now we're coming up to Nicholas Cruz. Which one are we on now, madam? Nicholas Cross?
Cross.
Thank you. Nicholas Cross, 11 and 12.
Your Honor, I would like to, so that we don't have problems with the clerk. There is no blanket appointments. The judge indicated he will appoint individually. So unless I hear it, and inquire about it, I don't want to have a miscommunication with the clerks.
Here's what we're going to do, counsel. I'm going to appoint the public defender to all matters now,
Judge,
unless otherwise stated.
Judge, I would respectfully ask you to do it individually as we started today. Otherwise,
okay,
if you don't mind, because I would have done a lot different this morning with the cases that you already heard. So
okay, let's proceed.
All right.
Nicholas, we have here Nicholas Cross. Failure to appear. Judge said bond at $1,000 remain unchanged. And we got Nicholas Cross, failure to appear. The judge said you had $2,000 remain unchanged. Both failures to appear. Have a seat. Next matter will be Nicholas Cruz, number 13, 14, and 15. Yes, sir, we got a bond exoneration. What normally happens, and the public defender appointed, Madam Clerk?
On this, the Cruz?
Yes, now we got appointed for Nicholas Cross, and now we're Nicholas Cruz. Bond exoneration, the bond will be reinstated to the original state, madam. We can double your bond or put it the way it was, so I'm going to give you the original bond, public defender appointed. Next matter will be Cunningham, George Cunningham, number 16. Obstructing traffic. Yes, sir. You have the money to pay for your own attorney?
No, sir.
Public defender appointed bond will be $150.
Yep.
I'm reducing your bond. Probable cause, sole limit. Next matter.
Your Honor?
Yes.
I believe I was pro se. I don't believe I signed for a public defender. And I wanted to.
Okay, we put him at pro se, madam.
He did
Scott
fill it out.
Everhard. I reduced your bond for you, sir. You did a good job helping yourself. I put it down from $250 to $150.
Sir, any amount of bond for me, I'm indigent, is unreasonable. I'm a veteran. I did 8 years. Any amount of bond is, I have some severe medical problems, which I'm going through treatments for right now. And $100 is $1 million to me. It's unfair. It's not fair and reasonable to me. I have no way to get out. It's for, I mean, even the probable cause, I was sitting on the ground holding a homeless veteran sign. And I have some severe medical stuff going on right now. It's severely hampers my life. It caused me some greater harm for I mean, I'm a homeless veteran. I did 8 years. I'm honorably discharged. Lived here 8 years. I've never fell dip here. I mean, I have no problems coming to court.
What were you doing sitting on the ground?
I was having vertigo real bad, and I'm taking medicine for that.
Let's see what your record is like. Dealing in cannabis, intimidation.
No, that's somebody else. That's not me.
I'm looking at George Ellis Cunningham, sir. That's you?
There's no dealing drugs in my record ever. Something miscorrected there.
Dealing in cannabis, intimidation, criminal mischief, petty theft, injunction, violation of injunction, violation of injunction.
There is petty theft, violation of injunction.
You need to be quiet. You need to be quiet. I'm speaking now.
Okay, sir.
Retail theft, prior arrest, DUI, cannabis, disorderly intoxication, felony battery. Now your turn to speak. Let's hear you.
I think I need a lawyer now, because I've had no felony batteries. I've had no cannabis. I don't know what's. I have had stolen identity, and I've been arrested here, and they've let me go before, but I've had none of them. I have had the open container, a violation of a probation, violation of a restraining order, and this, but I've never had a drug charge or a violent charge. None of that. Something is definitely wrong with it.
Well, they stole your identity probably, huh?
It's documented here. I do have stolen identity.
I would suggest you fill out a paperwork for the public defender, sir. Madam Clerk, having reviewed his record and have a chat with him, putting back his bond at $250.
Thank you.
Have a seat. But since he did not fill out a paperwork for the public defender,
He did, Your Honor.
well, if he did, then he's going to get the public defender. I thought he said he did not, and he
No,
did not
Judge,
want
he
the
said
public.
he didn't want one.
Oh, he didn't want one.
Right.
Well, on second thought, you said he might want one now.
Your Honor, I need, no. Judge, I'm not going to argue with your rulings, but I need to know who has filed, who wants the lawyer, and if we're appointed. I'd like it to be announced on the record. What's happening is you're questioning the defendants, and then at the end, you may or may not appoint. I'm having difficulty with the paperwork and realizing what do we have and what was done. So I'm asking the court to please make an effort to, on the record, if there's going to be an appointment.
Here's what I'm going to do, counsel. Here's what I'm going to do from now on. Madam Clerk, the public defender is appointed on all matters unless otherwise stated.
Judge?
That's what we're going to do.
I'd already asked you about that. You treated the defendants that came through this morning differently. You're treating the public defender clients differently. And I don't think that's fair. I don't think it's right.
Sir, have a seat. On Cunningham, madam, the one that we're still on number 16, the bond will be $100 cash or surety.
Yes, sir.
Next matter then will be Hackett, John Hackett.
Hey, you see what
John Hackett, is that the one we have now, Madam Clerk, or Everhard? Which one do we have?
Not Everhard.
Number 19. Public defender appointed on all matters unless otherwise stated. Public defender needs to be heard. Step up and be heard on all matters. Scott Allen Everhard, burglary of a dwelling, grand theft. Find it probable cause to hold him in each and every count.
Judge, we don't waive.
Yes,
Judge,
sir.
we're asking that you please be the same and consistent with every defendant that has come before you. You've treated the ones so far differently. And I don't know why, but...
In what respect?
You read the information, you read the probable cause affidavits, you questioned them on their, where they live, what they do, what kind of work, and then at the very end of each one so far that we've heard, you made an appointment. So if you're going to be consistent, which I'm asking the court to do, continue on, read the informations, read the affidavits, question them, and then make your appointments, if that's
All right.
what you want to do.
I understand that, and I'm not doing what you want me to do. You will do what I want you to do. So you have a seat, and I'm appointing the public defender to every case unless otherwise stated.
And
Now, if you want to work with me,
what I respectfully ask
if you want to work with me and you want to give me some suggestions, fine. But right now, have a seat. You will do it my way. I don't do it your way.
Your Honor, I've asked you for due process. I've asked you to be consistent. I've been respectful.
I don't think so. I don't think so. You're confusing someone who's a friend as opposed to someone else.
I'm sorry, Judge. That's uncalled for. That's totally uncalled for. Now, I've been 30 years practicing, and I've never had a difference with a judge. I say something to them, I'm respectful to them.